Good morning. Welcome to the second panel for the day, and we're going to shift to more of a private law focus at this point. And the question before us is posed as, is law and economics anti-democratic? And just to set the stage for that question, I think that it's drawing on a certain strand of law and economics that takes a normative view of the value of efficiency and maybe is occasionally skeptical of legislative incursions into the genius of the common law. We have three eminent scholars well qualified to tackle this question. Our own Brian Simpson, well known as a historian of the common law and other topics. And then he's going to be joined by Bob Ellickson and Henry Smith, both of Yale, well-known law and economics scholars as well. So the structure that we have agreed upon is that we're going to go, I think it's in reverse order of age. Is that what we've selected? Yeah. So Professor Simpson will start, and then Bob and Henry will follow up, and then I'm going to save a little time for the panelists to respond to each other and maybe throw things at each other, I don't know, and then we will open the conversation up. And same rules as last time. If you would like to pose a question to the panelists, we have microphones set up on either side here, and you are encouraged to make your question succinct. Brian.
Okay. Well, speculation on the nature and proper form of judicial decision has been going on for a very long time. Let's go back to 1345. There was a slack day in the Court of Common Pleas, and the lawyers started arguing about how judges should decide cases. And one of them said, the counsel said, well, you've got to follow the traditions of the court, because otherwise people won't know what the law is. And the second judge said, oh, no problem about that. Law is the will of the justices. And the third judge was very shocked by that, and he said, certainly not. Law is reason. And they've been arguing about it ever since. And let me take you forward to the Federalist, number 78. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequences will be the substitution of their pleasure to that of the legislative body. So that's linking anxieties about the legitimacy of judicial decision to the notion of democratic societies in which the people should be on top and decide what the law should be. Back in 1345, they weren't worried about that because democracy hadn't really been invented yet. And other people worried about the legitimacy of judicial decisions for other reasons. Jeremy Bentham was objected to them because of the arbitrary nature of decisions. He said, the common law is like hitting a dog to teach it how to behave well. You wait till it does something wrong, and then you hit it. And that's the way the common law works. So these anxieties have gone on for a very long time. In relatively modern times, there have been two theories associated with the law economics movement which have fed into this sort of discussion, and I'm going to state them in a very, very simple and simplistic way. One is an explanatory theory. That says that the common law has in fact evolved and been driven by the pursuit of economic efficiency. That inefficient rules are rather like giraffes with short necks on the Serengeti plains. They don't last long. And so it's the way it evolves. It's a sort of determinist explanatory theory. You know, you can easily mock this. You know, you say to yourself, you know, what about the old rule in Shelley's case? How efficient was that? Still around in Arkansas, so they say. So it's quite easy to mock this theory, but there we are. The other version is that common law decisions ought to be driven by respect for the value of economic efficiency. That can take a strong form in which people argue that should be the only value, or weaker forms of the theory say, no, it's an important value that judges should pursue in deciding cases, but not the only value. Why are there problems about this in democratic societies? Well, the first is, when did the people say this, or say that this was what they wanted? Is there a law out there passed by a legislature saying, judges, get on and pursue economic efficiency? Well, there's no such law. So when were the people asked? Or how do you give this idea democratic legitimacy? Second problem is, most people think that in democratic societies, a variety of different values are pursued, of which only one is the pursuit of economic efficiency. I think it would be pretty stupid to argue that this should never be a factor. Indeed, it would be quite easy, I'm not going to do it today, to produce cases back in the 17th century in England, or even earlier, in which it's quite explicit that a court decision is to some degree driven by notions of maximizing wealth. They don't use the language you use today because they hadn't read Adam Smith or anybody, but the idea is lurking about there. So that's a second sort of problem about the strong version of this sort of theory. The third problem, I think, is this. If the explanatory theory is correct in its strong form, then common law decision is driven by economic efficiency, whether we like it or not. It's just a fact about the world. It's no point asking the people whether they want this. It just happens. It's as silly as saying to the giraffes in Serengeti, are you in favor of Darwin or aren't you? It would be a fatuous question to ask a giraffe. And so if you think that this is what happens in some sense inevitably, then there's no question of democratic legitimation any more than you require democratic legitimation for Einstein or whatever. Now, I think in earlier times, insofar as people thought about this at all, and you must realize that most judges and lawyers at most times in legal history are sublimely uninterested in discussing what is the nature of judicial decision. They just don't worry their little heads with it. The first person in America who wrote a book which was explicitly directed to this in a full sort of way, I suppose, was Cardozo. Most judges don't bother. But I suppose if they did bother about it, what they might say is something like this, that judges ought in judicial decision to respect the peculiar legal conventions as to how you justify propositions as to what should be done. A legal convention might be that you have to respect the decisions of the Supreme Court because they are binding on you. That's a specifically legal reason. They might also have said that insofar as respecting legal authorities, juristic opinion, earlier case law, views of text writers and so forth, doesn't seem to point to a clear solution, then what judges should do was pay attention to their unsophisticated, if you like, common sense awareness of the sorts of values that are accepted in their society. For example, if you have a very difficult case and the judge said, I've read all the books and read the cases and it sort of goes both ways, so what I'm going to do is toss a coin. Now, coin tossing is not in our society regarded as an appropriate way of deciding cases in our courts. It's regarded as a perfectly good way of deciding who plays first in the game, but it's just not part of the conventions. However sensible it might be to save a lot of time by doing that, it's just not an accepted convention. Finally, I find that the more extreme versions of either the explanatory theory or the normative theory have the disagreeable characteristics of theories where one size fits all. That, I think, is not the sort of criticism that can be made in the more sophisticated arguments about the role of economic efficiency in judicial decisions.
Thank you, Brian. Next up will be Bob Ellickson, and he has to stand to talk. He's like me.
As Adam indicated, this is the private law panel. All the other panels are public law panels. Those of us who are involved in private law, as we three are more than most of the other speakers, actually don't regard this as an inferior form of law. We actually think that human interactions, I don't know if I can speak for all of us here, that the basic forms of human interaction turn more on the foundational rules of private law than on public law, that you honor another's bodily integrity, that you keep your promises, that you honor the work product of other people and whatever. These are much more foundational and important in the end than the public law topics to which many conferences eventually devote too much time. So anyway, that is our subject matter to fit in this conference, to fit in our panel with the rest of them. We are given a very interesting phrase to start with. Adam mentioned, is Law Economics Anti-Democratic? I want to use the first phrase because I was deeply puzzled by it, called the people's common law. This has, to my mind, sort of a Stalinist flavor to it. And not the sort of phrase you would expect at a Federalist Society conference. One thinks of the People's Republic of Korea, one of the outstanding democratic institutions in the world. And so what is going on here? So let me try to give you my understanding of what perhaps was the impulse behind this phrase, the people's common law, and indicate why I, in fact, don't reject this understanding of it. There may be others that people in the room, maybe my co-panelists can offer to the group. The understanding, which is not possible, I think, here, is that actually the people create the common law. Common law is created by judges. If you ask most Americans what the common law is, as opposed to civil law, they would just be puzzled by the question. They have no idea how to answer it. And they are not exposed to the basic rules of common law. When you came to law school, most of you read cases such as Hadley against Baxendale and Paul's Graph and Pearson against Post and whatever, and this was brand new for you. Most people, they occasionally read paragraphs out of Supreme Court decisions on public law issues. They have no clue about the common law. So how can the common law then be the people's law? So I think the impulse behind this phrase was that, properly developed, the common law should reflect the practices, traditions, and customs of the people, and that's the legitimate way for the common law to evolve, and to bring in extraneous factors of any sort would be to corrupt the common law. So a common law, the phrase we often use in law is custom. In fact, the common law does look to custom in all of its areas, but only looks to custom partially. And I will now argue that, in fact, that is the correct approach for the law to take. That would be a great mistake for the law to slavishly follow custom, that if the meaning of the people's common law is the common law has to follow custom, this is both descriptively false and normatively a very, very bad idea. I think it is a conception that very much appeals to people who join the Federalist Society, because the Federalist Society tends to consist of people who are either kind of Burkean traditionalists or libertarians. And if you are a Burkean traditionalist, basically the people's tradition should be incorporated into the law, so you kind of like that. And if you're a libertarian, usually I think you're kind of for small government, and you might have the instinct that following tradition would lead to smaller government than otherwise, so I can understand the appeal of this notion. But let me indicate why, in fact, the common law does not just follow custom. I say this as someone, and probably it's the reason I was invited to participate in this panel, is compared to most law professors, I am a huge fan of custom. I am a huge fan of leaving private ordering to civil society as opposed to shifting it to the state, and to rely on custom and norms and so forth is a way of doing that. But here, very briefly, are three ways in which custom can fail, and in which case we don't want the people through their customs to create the common law. One is, just to remind you how much you've learned in law school, custom may lag, to use a famous phrase from the T.J. Hooper opinion by a learned hand. The notion here is that social practice may get caught up with inertia or at a suboptimal equilibrium, to talk in a fancier way, and that law sometimes usually can jog the rules from that suboptimal equilibrium where it is stuck. A second reason is one that Henry Smith, the next speaker, is developing in an article, which is that custom is very vague. So if you are invited to a social event, you often, in fact, don't know how to dress. To take a typical example, you are puzzled by what the customs should dictate for you. And an advantage of law in many situations is it's clearer. And the fancy way to talk about this these days, of course, is to say the transaction costs or information costs are lower with some legal rules than with customs, and that's a disadvantage of custom. And thirdly, a thesis I developed when I wrote a book about these sorts of issues, my own view is that customs often evolve efficiently for the group that creates them, but they can be very bad for outsiders to the group. A classic example being the Jim Crow norms of the South, which, let's assume, were good for white Southerners. Whether that's true is, I think, not obvious entirely in the long run, but they were certainly just very bad for African Americans in the South and whatever, and so therefore customs are, in many instances, very inappropriate for law. So the law should not follow the people's customs, and therefore I reject this Stalinist conception of how the common law should evolve. Now in the remainder of my remarks, let me turn to law and economics. If the law is going to look to something else, it can reason any sort of analysis. It's not obvious to me why law and economics is the big bogeyman here. That is, why is it not critical legal studies or feminism or the legal process school or something like that? So I am intrigued by why law and economics was singled out, particularly in a Federalist Society gathering, as the great enemy of traditionalist law. One possibility, I think, is that it is the dominant paradigm. I think both Brian and Adam have mentioned the notion that many law and economic analysts stress a particular goal, that of efficient allocation of resources, that a lot of people regard as normatively thin, and I think that may be why it is a particular target. My own view, descriptively, and maybe Brian in his later remarks can refer to this, Brian is the great scholar on the case Keeble against Heckring-Hill, involving a battle between duck pond owners in the early 18th century. It's in the Duke Minier and Creer casebook that I assume is widely used here at Michigan. My own view is, if you want to explain that court's analysis of what it is about and how it distinguishes competition as opposed to interference with production, that a law and economics analysis is about as good as you can get if you want a kind of a reductive description of what is going on in that particular case. So my own view is, although I don't embrace the strongest conceptions of descriptive theory that the common law gravitates always toward efficiency, I think it is as reductive theory, it's as good as we have. My last point, since my time is ending, is basically a question for Brian and others who I think are more skeptical of law and economics, and this is also for the members of the audience, which is there's this conception that law and economics is delegitimizing the evolution of the common law. And so I ask you to identify some examples of where judges have gone wild, have been influenced by Richard Posner's analysis, or that Richard Posner himself has run wild and corrupted the common law by bringing in law and economics concepts. And I'll have a better understanding, I think, of the unease behind this, the formulation of this panel, if you can come up with some actual examples. My own perception is Richard Posner, for example, is usually more bark than bite. Another case, if you're studying property, is the famous, it's a public law case, the Chicago Board of Realtors case involving a tenant reform statute in ordinance in the city of Chicago, where Posner talks about how economically stupid it all is and how these people have no economic understanding at all, and then sustains the ordinance. So that my sense is I am interested in getting examples from people about where law and economics has polluted and delegitimized the lawmaking, common lawmaking process. Thank you.
Okay, well, first of all, I endorse the focus on private law here, so there won't be any conflict about that. And I'm not sure, given that we're a little bit perhaps unclear, maybe this is a case of a vague custom in the making about exactly what the topic is here. I'm not sure that I will be synthesizing or coming in and tying everything together. I'll just try to be provocative in my own way, maybe. So is law and economics anti-democratic? My answer is more often than it needs to, but I'm not going to go through or even endorse, particularly endorse, the familiar litany about how concerns with efficiency will lead to baby selling and the end of the world and all these scary scenarios. I don't subscribe to any necessary connection between those in the first place. No, and maybe surprisingly, my culprit here, as far as the tension between democracy and law and economics goes, is maybe a little unexpected. It's legal realism itself. Okay, so legal realism is the problem, is what I'm largely going to argue. And now you might say, well, legal realism, that's dead. And I'm going to say that in some sense it rules us from the grave. As the saying goes, we are all realists now, and to me that's the problem. Now I'm going to suggest that there's nothing really wrong with law and economics inspired theories, or theories in general, or legal realism as a theory for that matter. It's when heroic judges and academics, at least heroically self-conceived judges and academics, offer to rework the world with purported solutions to micro problems, getting into the nitty-gritty with complicated economic theories, that we're really in legal realism territory, and that's the real source of the problem. But that's a limited problem, though it is. So most movements in legal thought do draw on legal realism, and it may come as a surprise to some that law and economics is not an exception. As Tom Merrill, who doesn't have any responsibility for the things I'm about to say, has tried to show with me in an essay, Coase himself, in his FCC and social cost articles, and quite understandably given his goals, was really not just a realist, but a hyper-realist about property. So let me start with property, which is a good starting point. These assumptions basically were reflected throughout his article, but especially in the part about nuisance. And the idea was that judges, whether they knew it or not, and the more they knew it, the better, would be parceling out stick by stick who gets the right to do what in a very narrow and somewhat ad hoc way. So who gets to make the noise, who gets to trample the crops or have the crops trampled free, and so forth. And this even extended to causation, so that trampling is caused by trampling animals and by trampled upon crops. And I suppose we could extend this to the question of fists and noses when it comes to evaluating punches, although we don't do that in everyday life. And I will suggest that this Coasean agnosticism about causation is a symptom of the problem. Theoretically, it's perfectly fine. It's useful to think about that sometimes, but it's good as far as it goes, but it doesn't go really all that far. That there are, to take Coase further, transaction cost reasons, not to mention moral reasons, why we do not define entitlements that way. Who does what to whom, who invades whose column of space, are all good ways of approaching a problem ex ante, and that makes the question quite simple and solves our problems most of the time. Not all of the time, and that's where we need to override some of these initial decisions, but we should be sparing with them and not just take the legal realist bundle of sticks and start parceling out ex post at will. Indeed, if we take a look at this from an ex ante versus ex post point of view, legal realism and law and economics in general are kind of two minds here. That, of course, law and economics is worried about ex ante incentives, but this deliberate ignorance or downplaying of pre-existing legal baselines is characteristic of much of law and economics, and I think that's quite unfortunate for information costs, among other reasons. So that brings me to the question of Bentham. So we could wheel out Bentham right now if we wanted to, I suppose, and I guess metaphorically that's what we're doing. And I guess my objection to the sort of Benthamite cast of legal realism is this technocratic approach. Now, of course, Bentham was no fan of judges in the common law, so in some sense, to the extent that judges are implementing some of this technocracy, to call it Benthamite is a little bit ironic, and he might be actually spinning if he's actually in his grave. But the idea here is that the legal realists, with some exceptions, were big fans of Bentham, and I think that's quite unattractive for the reasons I'm talking about. Now, one irony here is that law and economics, to the extent it gets down into the weeds and is talking about particular issues, is not resting on some kind of general equilibrium analysis. It's partial equilibrium analysis of the most partial sort. And there are aspects of economics, information cost economics, cognitive science and economics, the theory of second best, which all point to the dangers of this, but a general equilibrium analysis is just simply too difficult in most cases. So how to approach a complex system, which of course the law and not to mention the law in context certainly is. One might think that this is just an obsession with property. Now, all of us happen to be property scholars, which I'm not sure what that says, but you might say, well, okay, my hang-up here about legal realism is just my objection to the bundle of rights as taken too far by the legal realists, and I would say that that's not true. Take another example, the economic loss rule in torts. Okay, so until recently I thought actually torts was maybe the one area of private law where legal realism is the most legitimate, that we have to regulate these activities and who knows what and so forth. And the economic loss rule seems to be a good candidate for economic analysis. It basically says that liability for negligence is going to be limited, is going to be denied where there isn't any damage to person or property. It's just pure economic loss. And of course we've got lots of theorizing, lots of speculation about whether this is efficient and what kind of exceptions we might have. And now we even have economic analysis in the form of empirical studies about what courts are actually doing with this, and of course they're all over the lot and so forth. And what are the rationales? Well, maybe it's excessive liability, whatever that is, or foreseeability, even though we have a foreseeability requirement. And all this is actually pretty depressing that we don't make any more progress than that, although there's a lot to talk about. Interestingly, very recently, a more doctrinally oriented analysis came to my attention quite randomly, and it made the very simple point that the economic loss rule really is about only allowing recovery where somebody has an in rem property right, and that these secondary forms of liability, like people with a contract related to the damaged property, say it's a boat or something like that, the person who's hired the boat, that's just a matter of contract between the boat owner, who does have a right to recover, and the contractual party. And the idea is that the contract system, the tort system, the property system operate not completely but largely independently of each other, and the interactions between them are specified, but they're highly limited. Now, this way of thinking used to be the common coin in places like this, but it's largely a dead language, and it's high time, I think, to re-dig it out of the ground. It's not incoherent, it's not undesirable. It does require some attention to what is normal and what's an exception, and it does give these legal baselines some privileged status, and it focuses our attention on how and when they should be overridden, but I think that's all to the good. Now, is the traditional approach that I've described here efficient? Really, that beats me. I'd say at a structural level, it does lead to a certain simplicity. It certainly makes intuitive sense in terms of a few very simple efficiency stories, but not really at the level of individual rules. It's really an overall system that has a certain plausibility and seemed to work pretty well and can be analyzed in economic terms. But the idea of actually applying it directly, economic analysis, to its details seems to me fairly heroic. Now, I was going to talk about custom and so forth, but Bob Ellickson said it better than I could, and I'm not inclined to disagree with myself, so I'll just skip some of that part and we can talk about that. Now, I also haven't said much about democracy, and I was thinking of saying a few sort of bomb-throwing things about that, and maybe I'll just cut that short. But
no, now's the time.
Okay, all right. Here it goes. Now. The idea, it's a little hard to say what this topic is, partly because, really, none of us have talked about what is democracy and so forth, and that would take too much time. I will say that there is, and this may be a little unfair, but I don't think so, a certain very crude notion of what democracy is, that the people should get what they want, okay? And nobody really usually says this quite so crudely, but actually you do hear that sometimes. But it's implicit in a lot of what people say, and then the idea is that people coming along with economic analysis are just meanies because they're preventing people from getting what they want. Now, I just said technocracy and so forth I'm not for, but when it comes to reminding people that you can't always get what you want, that there are constraints, that there is scarcity, I think that's actually one of the most salutary things about law and economics, that as voters we have a full incentive to vote, get the warm glow of voting for X, Y, and Z, and we really individually won't feel any negative effect from our individual vote. And it's not at all clear how all those things fit together. I mean, obviously, this could be a problem. It could even be a tragedy of the commons if we think of a sort of philosophy. Sorry, that was a big slip. Property analysis of this kind of problem. Now, the scarcity of resources, scarcity of time, scarcity of attention, all of these matter, and whether judges should be implementing something based on that is a good question. I tend to be a little skeptical as far as the details go, but to remind people that there are these scarcities out there sounds trivial, but it actually isn't. And a law school is a very good place to realize that the idea of the principle of scarcity is easy to forget. The scarcity of the principle of scarcity is actually real, is certainly true. Okay, so reality has a way of intruding in law and economics to the extent that that helps that happen is all to the good, in my view. So in some legal realism, my main culprit here, as it plays out in real life, not as a theory but as a method of dealing with details, is I would call it a colossal act of vandalism. So the barbarians are not at the gate. No, we are all barbarians now, but the idea that law and economics has to be a vehicle for overweening technocracy instead of a path back to sanity is not anything necessary, and I'd much prefer the latter. Thanks.
Okay, now certainly you all have had an opportunity to find something to disagree about or something disagreeable to say. So, Brian, we will give you the first opportunity to be disagreeable.
Well, I don't think I'm going to be disagreeable. I really don't disagree with Bob's view that in certain cases it's perfectly plain that one value that judges were attending to was some notion of maximizing wealth. There's a lovely case in 1628, nuisance action against somebody running a brewery, and one of the arguments quite explicitly made was that if this smoke nuisance is accepted by the court, so the brewery has to pay out a lot of damages or close down, that's going to be bad for the Commonwealth because there won't be enough beer, and everybody knows the British cannot live without beer. Now, there it is, it's quite explicit. I'm just very dubious about the sort of generalization of the argument that this has been a dominant factor or that it can be used to explain more or less everything, a view which is taken, I think, to its extreme in Posner's book, The Economic Analysis of Law. The only other comment I was revising what Henry says. It is true that the realist movement haunts us all, and you know, it's supposed to be over, but it isn't over. And law school teaching, of course, encourages a sort of realist attitude of mind, because we spend most of our time arguing about the fringes of legal rules and looking at cases which don't seem to produce conclusive arguments going one way rather than the other. And we think the whole law is like that. It's a complete state of muddle. And it's an unrealistic view, but it's also, I think, encourages people to think, I wish we could get at some other sort of non-legal analysis which would give us clarity, certainty, tell us where to go, and go away from the messy business of court decisions to some hard empirical stuff based on economics and so on. That this is a sort of looking for a certainty which we feel we haven't got still today in the law, and I'm not sure that there's anything more certain about economic arguments in pointing the way together than there is about legal arguments. I'm very dubious about that, but I think that's one of the attractions of the more extreme versions of the law economics movement. And of course, we have a problem here because Bob here is not one of these crazy extremists, so it's perfectly plain he isn't. What we really need is a crazy extremist here to set the argument up.
Can you name names?
Well, I'm not going to name any names.
No, I'm interested in who are the crazy extremists, either in academia or on the bench.
Well, I think I think Posner's writings, or some of them, okay, as opposed to his behaviour on the bench, which is quite different, has carried some of these arguments to extreme points in his book, Economic Analysis of Law. And in fact, there was always this sort of move when I was in Chicago from people who said, one day Judge Posner's going to say, it was all a joke. But he never has said that, but he is a person with a twinkle in his eye and a great sense of humour, right. And one sometimes wonders whether some of it isn't just pushing it to extremes, possibly sometimes as a teaching technique. I mean, his famous article on the free market in babies, which people say is shocking, and there's nothing shocking about it. It makes you think hard about the virtues of the market system in allocating goods. Here the good is, of course, a baby, which we don't like to think of as a good. I mean, if anyone's had babies, no, they're not a good, they're a bad in the middle of the night. But, it is a technique for making you think hard about the merits of markets as a way of allocating resources. And I think it's a wonderful article, though some people think it's an evil, wicked article. I don't think that at all.
I have the same view of Richard Posner's actual beliefs. One principle of economics is you look at revealed preference. You look at what people actually do, not what they spout off about things and whatever. So Posner, I think the economic analysis of law, which he first drafted in the early 1970s, did express the sorts of things that would get Braun upset, and I think most of the members of the Michigan law faculty, this law school is regarded as one of the centers of skepticism about law and economics, and my guess is from Bill Miller and Jim Creer and James Boyd White and others, you're not getting unalloyed pro-law and economics analysis. The interesting thing for me is that when Posner got on the bench, he, in fact, maybe you can identify some decisions that he handed down that were outrageous, but I'm not sure I know of any. And then his writings, actually, he claimed that he became a pragmatist. And I'm not exactly sure what that means. I think it means you consider the kitchen sink, you consider all sources of analysis, you consider all values and whatever, and that's the real, by revealed preference, that's the real Posner here. So I'm a little bit worried about what the bogeyman is here. I mean, I repeat that question and invite members of the audience to nominate either particular judges who have abused their role in developing the common law by stressing efficiency too much or relying upon abstract law and economics too much. To support the general theory that there is a lot of descriptive power in the notion that the common law involves efficiency, let me name a couple of cases for the students, both nuisance cases. where the common law preceded law and economic analysis and showed the brilliance, if you will, about judges deciding real cases and coming up with solutions. One is the famous Boomer against Atlantic Cement Company involving the remedy for a polluter who pollutes over a wide territory. 2 years after that decision, Calabrese and Willamette wrote a very fundamental article saying that when you had large numbers of parties, you probably should not give out injunctions. You should rather only give the remedy of damages, which is by and large what nuisance law does. Henry, I think, may be a critic of this, so he may regard this as a retrograde decision and whatever. My point is that this decision preceded Calabrese and Willamette, that the implicit kind of analysis that Calabrese and Willamette might have applied was applied prior to their article. Calabrese and Willamette also came up with a case called something called Rule 4, which is that an injunction would be available only if those benefiting from it paid for it. And then, lo and behold, it turned out there was this decision, Spur Industries case, where a court had invented that remedy without influence of Calabrese and Willamette, that this was a so-called brilliant insight of law and economics, in fact, emerged from the bottom up. So I think there are lots of instances of that sort, and my own view is that if you want a reductive theory of what's going on in the common law, that the efficiency tendencies of the common law is, in fact, the best one we have, although I do regard it as overly reductive.
Yes. Okay, so I would like to pick up on a couple of points that Brian and Bob just made. I do think that the central issue for me is what's at the core and what's at the fringe. And it is true that in law school we spend a lot of time on the fringe. We spend a lot of time on the difficult issues, and we give students and ourselves the impression that that's the way it is all the time, or that somehow calls into question the basic answers that apply in most of the situations. Take property rules and liability rules. In real life, liability rules are far more exceptional than they are in law review pages or in law schools. And there's a reason for that they are simple, that they delegate a lot of authority to owners, they work well most of the time, and when we're talking about liability rules, we're usually talking about a problem that's gotten so out of hand where there really truly are high transaction costs and yet high stakes that we need to go for something else. But that notion really does not, that is not the dominant theme in law and economics. It's usually that we can have yet another, even more clever round of liability rules to take care of the problems that people have noticed with the previous round. And that's not the way the law should evolve, and thankfully it, by and large, doesn't. I'm not, Bob, I think, deliberately brought up Boomer and Spur because it ties into these themes. I'm willing to grant that Boomer is a close case. I mean, I guess that does put me on the fringe because people usually regard it as self-evidently correct. But think about moving a polluting cement factory into an area. Maybe we would want a process that's a little more ex ante, like we have for condemning easements, private easements in certain states, that we want the homeowners to have some kind of due process right to say, no, there's a better place for this plant and so forth. The idea of just going ahead and building it and letting a judge sort everything out afterwards, I think, is not a terribly good idea. And the damages, for that matter, in Boomer were a lot higher than the Court of Appeals was talking about. And I do think that Boomer itself leads to a caution about doing that sort of thing too often. It may well be at the end of the day that we need to use damages in high transaction cost situations in the sense of a lot of affected people, but I don't think it's nearly as obvious as people say. And I think Spur and Rule 4, I would call Spur rather spurious as a pro-law and economics case. Number one, Spur is the only case that's ever done this. I think that gives me pause, not just to begin with. Furthermore, Rule 4 is basically destabilizing the basic pattern of entitlements. The whole reason in Boomer and cases like that we go from property rule for the residents to liability rule for the residents is that the property rule is too stringent. We do not have the same situation when we supposedly flip things around and do the mirror image. It's not a matter of flipping the entitlement around. The entitlement is not the little stick as to whether we will have pollution or not. It's really whether people get to invade and so forth. And the basic package of rights does not include a right to pollute. So the idea that Rule 4 is softening some kind of ex ante entitlement that we've put out there is just not right. And so I'm not denying that there could be some scenario where Rule 4 is appropriate, but the idea that, oh wow, if we just liberate ourselves and think in terms of mirror images and so forth, that's exactly the problem of not respecting these clumpy entitlements that we've agreed on ex ante, and we will only override for very good reasons. Rule 4 is not doing that. Now, not to mention the fact that Rule 4 came up, I mean, this is another symptom of how weird it is. The procedural situation there of the developer suing and so forth provides, I admit, an alternative explanation for why this isn't more widespread, but I do think there are normative reasons to be very suspicious of Rule 4 in an in rem context where lots of people are involved. Actually, you can regard Spur as sort of an equitable approach, and one big weakness, I think, of law and economics is that it does not take equity seriously. The idea is, oh, we want to be ex ante. We don't want to think in terms of ex post discretion. But there are situations where ex post discretion is appropriate and less harmful, particularly when we're talking about identified, almost quasi in personam, really face-to-face parties, and we're not making a rule that will spread out into the world. So I think there's the problem with the sort of conventional liability rule approach to Rule 4 and Spur is that it really strips out a lot of detail that's there for a reason, and that points to Rule 4, if it's valid at all, to be really very squarely located on the fringe and not at the core. And, you know, every year I read exams where people say, oh, well, this is a core case of Rule 4. Of course that's what the court would do. And I'm like, how did you get that out of my course? But I guess it's a tide that's overwhelming, at least locally. Yeah.
Thank you, Henry. Was there any rejoinder at that, or are we ready to open things up? Okay, fair enough. Well, we have two microphones set up here, and if you can come to the microphone and pose your question, we'll try to maintain things on an orderly basis.
Hello, Ryan Braun from Oklahoma City University. First, my apologies, they lost my luggage, so I don't have courtroom attire. But Professor Ellickson, you asked for examples of sort of judges gone wild, and I do have, of course, I think it was already
Sounds
answered.
like the name of a good movie to me, yeah.
I know that Judge Richard Posner, of course, recently wrote a book, Not a Suicide Pact, with regards to the Constitution and national security. Do you feel that Judge Posner's views on national security and a flexible Constitution in times of national crisis, does that fit into the law and economics and realism model, or is he sort of out on his own?
Well, I'm thinking of just invoking the private law theme of this session and say the obvious, which is I am not an expert at all on national matters of national security, and I won't say they're trivial like I implied at the outset of my remarks and whatever, but I really don't know a whole lot about it. It's interesting to me whether or not Posner might run wild in his lawmaking and rendering decisions in the public law sector more than he does in the private law sector, where I'm more likely to know it. I totally agree with Brian that Richard Posner and also his son Eric, I think, are self-consciously provocateurs. And I know other law professors, some of whom are at this conference, who I regard in the same mode. I try to be a provocateur as well. And I regard it as pedagogically very, very stimulating. You know, it helps to stimulate and stir the pot. I think if you want to know Posner's true views, you look at his opinions, and I claim that there is quite a disparity between the bark and the bite, and that might be true in the national security area as well. So, but maybe I don't regard, I have the highest esteem for both Henry and Brian, but I don't think among the three of us would be hired to provide legal services on issues of national security.
Thank you, Professor.
Hosea Horniman from Liberty University. This is primarily for Professor Ellickson, but for the whole panel to comment on perhaps. You were asking about particular examples of how law and economics has sort of operated in derogation of the common law, if you will.
Right.
in, I believe it was 2003 or so, there was 2 cases in the Seventh Circuit. I believe Judge Easterbrook was the author of both opinions, Gateway and Pro CD, where specifically the rule, the common law rule of acceptance at the time of the sale of the goods that seems to have been applicable before that was changed to more of, it basically deals with something that's probably more close at hand to all of us, the shrink wrap agreements and the terms within the shrink wrap. At what point does acceptance happen? How can a party get out of? How can a buyer get out of the contract for purchasing the software? And under traditional rules of contract, it would seem that the contract, the offer and acceptance, took place at the point of sale. However, Judge Easterbrook, using law and economics principles, and basically said, well, it's more efficient, less transaction costs if we just allow people to return their computer if they get home and decide it's what they didn't want or it's defective or whatever, and said that, well, basically they've got to accept whatever's in that box, even though they never had a chance to even see the terms of the contract. Can you comment on that as far as, is that really in derogation of the common law, and does that cut against your theory that there aren't really any examples or none that you can think of?
Yeah, this is I'm somewhat aware of this opinion. I think Henry may know more about it than I can comment on it. I'm a mere property professor, and I do regard this largely as a contracts a kind of issue. I think the common law clearly changes, and one thing we need is both positive and normative theories about why it does change. If that was terribly destructive of common law traditions, one would expect a certain amount of chaos to have ensued from this invasion of alien law and economic analysis, which very much confounded buyers of software, buyers of computers and so forth, as opposed to their expectations. And I'm not aware of any such chaos. So this might be an example that, again, that this sort of law and economics here is a bogeyman and whatever. It's really hard to identify cases where chaos ensued. But some of you may know. Your generation buys these machines more than mine, and maybe you do know of situations where your behavior was affected and this disrupted your lives and whatever. So I again confess this is an annoying pattern, but I'm confessing ignorance of this area of law. Henry, you know more about this?
Henry, are you annoyed?
Yeah, I'm of mixed minds about Pro CD, partly because my main interest in it is the preemption analysis, which is actually more interesting, I think, from a property point of view, that he found that the contract here, the application of Wisconsin contract law was not preempted by the copyright statute, and he relied heavily on the in personam in rem distinction, and a lot of people who are more sort of directly functionally interested have had a lot of criticism for that. But I think that approach, his approach on that goes a long way, that there's some legitimacy to that. On the question of offer and acceptance, I'm less familiar with that aspect of the case, but my understanding is that there's an extra level of problem here that, first of all, this is a UCC problem, and there may have been parts of the UCC which address this more directly, being a license rather than simply a contract, and so there's some kind of muddle there. I agree with Bob that as far as if this were really truly a common law contract case, the idea of interpreting offer and acceptance differently with changing technology doesn't surprise or shock me. But the Pro CD case itself is a very sort of strange intersection of a lot of different areas of law.
This is quite a short point. Richard Epstein, in an article, I forget the name of it or where it appeared, but he makes what always seems to me a very good point, that what you might call the fine-tuning of the rules of private law, it's very implausible to argue that that has big economic effects. I think one of the examples he gives is that if a business is thinking of locating in one state rather than another, they're not going to worry about whether the rule in Rylance and Fletcher applies in that state. A lot of these things we'll be fascinated by in first-year classes are the fine-tuning of private law rules, and it's implausible to suppose that they make much difference to the gross national product.
Tom, say something incendiary.
Tom Merrill, Columbia Law School. I'm a member of BAM, and I would like to denounce this panel. Fraud. No, seriously, when I saw the panel title, the thing that flipped into my mind was that the difference between democracy and law and economics is that democracy is based on one person, one vote, and economics is based on $1, one vote. And so you've got sort of a basically different metric for decision-making right there. And it seems to me that some of the issues that even private law experts confront might come out differently if you thought about them in terms of one person, one vote, as opposed to $1, one vote. One thing that occurs to me are rules of damages. For example, in wrongful death cases, the economics approach would tend to try to figure out what the expected earnings of the deceased were and how much earning power they had, what their lifetime discounted expected future earnings were, and award damages based on that, sort of a $1, one vote approach. More democratic approach, arguably, if you could call it that, would be to sort of set some kind of absolute scale for how much a life is worth, and everybody's worth the same thing. Another possibility that occurs to me is some of these fights over beaches and whether or not beaches and other types of assets should be open to the public or should be subject to private property rights. And the economist might say, well, if you open it up to the public, you're going to have a lot of litter, you're not going to have any lifeguards, it's going to have all these inefficiencies. And the democratic approach might say, well, we want to open up these resources so that every member of the polis has an opportunity to affiliate with every other member of the polis, the Carol Rose's Comedy of the Commons kind of vision, and that would be a more democratic approach to deciding those sorts of issues. So I'm wondering if the panel sees any other issues or disagrees with me about those being examples of issues where a kind of a democratic approach might lead you in a slightly different way than an economic approach.
All right. I'm going to try and impose some order here. Brian, is the life of a school teacher worth less than that of an investment banker?
Well, it was decided in English tort law, and I can't do the name of the case, but it's about the 1870s, that people got their actual potential loss of earnings and not an average sum. And that was one of those sort of critical decisions which, people don't notice because they think it's so obvious, but it's not so obvious. I think that one person as opposed to $1. I think one of our big problems in the modern world is that a lot of the law isn't dealing with persons at all in a straightforward sense. It's dealing with corporations. And where they quite fit into the democratic scheme seems to be very problematic because they're not individuals. They are artificial entities and so forth. And a lot of the law deals with this. I'm very struck when I teach property law that the discussions of the merits of property law, the demerits. There's a famous piece by Demsetz, which we all have to go home and take light, nourishing meals until we follow the argument. A famous piece. It's all about individuals, but actually so much property in America isn't owned by individuals, it's owned by corporations. Quite where they fit into the democratic theory seems to me to be problematic. I would have thought the Boomer case was driven by corporations trump individuals. I think it's a terrible decision, but some people think it's a wonderful decision. I think it depends on how you approach it.
Tom, I do think law and economics pays relatively little attention to issues of distributive justice and symbolic equality and things of that sort that the word democracy, I think, conjures up. The standard line in law and economics, of course, is from Caplow and Chevelle and others, is that when you're creating, you're working on issues like remedies for injunctions and whatever, that's not the occasion on which to give from corporations to the little guy or vice versa and whatever, that should be done through broader tax and spending policies. Now, my own view is everyone cares about, I don't know anybody who doesn't care about distributive justice, and one thing the law does in a lot of areas is provide for symbolic equality among people, one person, one vote being a classic case. The 13th Amendment, which abolishes slavery, gives a certain basic entitlement to everyone. Every state constitution creates a right to education, which is symbolically very, very important for distributive justice. So I think clearly those values come in. I don't think they come in centrally in most in the low-level areas of private law, like remedies for nuisance, like shrink-wrap contracts and whatever. Those are not the occasions, I think, to bring them in. And as I say to my students repeatedly, so much that it bores them, is that the doctrine never asks the judges to take that into account. The judges might sometimes take distributive justice into account in these low-level cases, but the doctrine never points them in that direction. The wealth of the parties is, in fact, if admitted, sometimes is reversible error as prejudicial in lots of private law cases.
Yeah, I'd just add that some of our private law, like corporations, can be thought of as a kind of mechanism, and it's not immediately clear that every detail of every mechanism, or even every mechanism itself, has to be quote unquote democratic in order to fit into a democratic society. I think the danger with common law decision making is when the decisions do implicate, when they become a substitute for other more democratically arrived at decisions, and when they don't. And sometimes the parts of the law that seem to sound the least inefficiency, like where we, in an earlier era, a court of equity would be acting, often those, not always, but often those are cases in which we're not setting the ground rules that will apply in a wide variety of cases. So I think a lot more attention to sort of when and why we bring in other values, or apparently bring in other values, is in order. And the tendency, I think, in law and economics and in law schools in general, not just law and economics, is to sort of smush it all together and not to make these distinctions. And when you do that, then I think many of these questions look a lot more puzzling than they do if you don't just mix everything into one big bowl.
Brian, up for you, Campbell. In your analysis of the tension between law and economics and democratic principles, what would you say to issues where the people's customary common law stood in the way of market efficiency, and the people, through their democratic processes, actually reformed the common law, such as the UCC is a big example, or maybe the e-sign statutes recently? These are cases where, through the democratic processes, have served the interests of law and economics. It's taken away some of the, what we say, the people's custom, and replaced it with the people's actual will now. And given recent statutes like that, would you really say that the democratic process and law and economics are really in opposition? Thanks.
Well, I am, although, as I say, more enthusiastic about custom than most law professors, recognize limits of custom, so I can imagine lots of situations where legislation would improve on the status quo ante when matters were governed by custom. So I certainly agree with the possibility that you advance.
Just to maybe throw some fire, do you have any thoughts on Lochner, particularly Holmes's dissent, maybe how that impacts law and economics, the whole social statics?
Well, we're constantly being polluted with public law here, and those of us who actually regard private law as far more fundamental. I mean, this is an interesting. It's interesting that people's perceptions are that public laws is what matters, and that con law is, So I'm sorry to say this. You can defend it, but that my own view is, if you look look at the really fundamental rules, a lot of them are private law rules. I'm sorry, I'm being a wise guy, so you should continue with your question.
Well, just this idea that, maybe this is some area that you can bridge public law and private law and talk about law and economics, and people seem to have a lot of opinions on Lochner. I just threw that out.
Yeah. Well, I would say, to see if Brian is the most skeptical of law and economics, don't you think that in thinking about an issue like Lochner, which involved wage and hour legislation in the employment sector, don't you think that law and economics could bring some insights into the effects of those statutes? They wouldn't necessarily decide whether it's constitutional or not, but isn't this a case where you're glad law and economics is with us?
Yes, I mean, I've no objection whatever to economic factors being taken into account by courts. What I'm skeptical about is this as a theory according to which that economic factors should take precedence over other values and some sort of automatic pecking order. I'm skeptical about the view that the development of private law has in fact been largely driven by the pursuit of economic efficiency, but I think it would be perverse to argue that economic factors shouldn't be taken into. I'll give you a simple example. It's a bit like Boomer. There was a case back in the 40s in England where an angling association sued a big company, British Ceylonese, for polluting the water so they couldn't catch these disgusting fish like pike and so on, which they wanted to catch. And this was a little guys against a big corporation, and they won the action because the company was polluting it. But then the judge said, well, wait a minute, folks, we don't want to close down British Ceylonese and devastate the local economy. So delay was imposed in the exercise of discretion on when the injunction came into force to give them time to clean up their act and so forth. Seems to be perfectly sensible. And the anglers didn't object to that either. They thought that's reasonable. It'll take them some time to clean this river up, and it did. But I don't see an objection to that.
Ben Johnson, and I guess my question, kind of coming back after Professor Merrill's question, I kind of view it's kind of a false choice between one person, one vote, $1, one vote. Economics is concerned with the idea of utility, which, and kind of running through this is kind of this impoverished view of utility that we can just match one util up with X number of dollars, and then we'll be able to find the correct allocation at some point. And so I'm kind of curious as to maybe where you run into the problem between law and economics and democracy is when our revealed preferences as to how we do things with our dollars are not necessarily how we would like them to be with our votes. And one example might be when they ask people, are we sick and tired of seeing the Monica Lewinsky scandal in the papers? And like 80% said yes, and yet it was like the highest circulation they'd ever had for a lot of major papers. And so it seems like there are a lot of instances where we as people fall victim in our private actions to our worser angels, but in our public selves, democratically and in other instances, we might try to call ourselves collectively and bind ourselves to some higher purpose. And so I kind of wonder if is in there somewhere a means to kind of introduce some equity into the law, especially in like after breach of contract or property, other places, where we can kind of enrich the notion of utility in our community to kind of account for the fact that sometimes we want a little more than what we display, and that the things that we value are not necessarily monetizable all the time.
I guess I'm the designated first speaker. Well, one thing I certainly agree with is that there's another value out here that in Tom Merrill's typology, for example, was not mentioned. I think people care enormously about their social status. That if you look at, in Rawls, when he talked about equality, didn't just talk about material equality and dollars and whatever, that there are other societies are giving out other things as well that are very, very important to people, and we don't have much of a handle on that. And, but that's another concern for people who are worried about this distribution of things. There is, I think it's, I'm struck that there's sort of a romance with democracy, perhaps, in the room, which is a greater romance than I have. The last panel indicated the flaws of decision-making through legislatures, and that how the initiative process as a corrective is deeply flawed as well. We have a lot of problems with making collective decisions and whatever. And again, compared to most people, I like the way much more decentralized institutions of civil society make decisions. That is through markets, which have underneath them a core of law, of property rights and whatever, but also norm making and norm enforcement through self-help and gossip and so forth. My own view is that's very often a better way for a society to structure itself than than to use government. So I'm struck here that in the Federalist Society session, of all places, there is this obsession with big government. So maybe I'm not capturing the thrust. I don't think that's Mr. Johnson's view of the world, but I'm struck by that aspect that we want a lot of democracy. The way I read the word democracy is we want a lot more decision making through government, and I'm shocked.
I'm going to intervene here.
Yep.
Brian, is democracy just a lot of cheap talk and posturing?
No. I don't think so. I come to democracy, partly for living in a democratic country, but as a legal level, I come to it because I do work on the European Convention on Human Rights, and the Convention on Human Rights was drafted to form a statement of the basic core values which were prerequisites to the existence of a democratic society. So that was an attempt to translate the ideal of democracy into a legal form. And in the negotiations, there was some resistance from some people to the idea of putting in anything about holding free elections and so forth, though it is now in the first protocol, because it was said that if you had freedom of association and freedom from arbitrary detention and a right to fair trial and freedom of expression and freedoms of this sort and so forth, you just get democracy, because democracy would appear if you had respect for these core values. So I think you can, and I have some sympathy with that, I think you can attempt to set out what are the values which have to be respected in a democratic society. I think the idea that democratic societies are just about the people getting what they want, or one person, one vote, are extremely simplistic views, because if you have one person, one vote, and that's it, then what happens to minorities and so forth? They're just crushed. And although Hitler didn't come to power through a popular vote, he did get a very big vote in Germany and so forth, and that vote was one which, insofar as it affected what he did, destroyed democracy in Germany. So I think you can attempt to state what these values are, though you can always argue about them at the edges and precisely how they work out.
Yeah, although I would make a plea for coming back to the idea that some of these private law topics we're talking about are too low level to really require a big intersection with foundational principles that would be the sort of entry point for judicial decision making of the most intrusive sort. I mean, if I'm not mistaken, the European, I believe it's the European Court of Human Rights, declared that English adverse possession law violated the owner's rights. And I think when we get to that point, the European Union has gone far beyond its usefulness, and so I find that kind of troubling. Going back to the question that was sort of the prompting of all this, I do think that some forms of reasoning that are sort of looked down upon by law and economics, like corrective justice or certain kinds of fairness arguments, can serve useful functions, not just in their own right, but also if you take a utilitarianism that's sort of high level enough, you can explain to yourself, if you happen to be one of those kinds of utilitarians, that maybe they're not so crazy after all. I mean, the idea of who invaded whom and so forth in nuisance really came in for a lot of criticism and sort of disdain, but actually there's a lot more to be said for it than that sort of maybe very low-level utilitarian kind of approach would have led us to believe. So that's not a complete answer to the question of what value should come in, but the idea that law and economics in its sort of low-level utilitarian form can sweep too many ways for other forms of reasoning to at least raise their heads, I do think is somewhat of a concern.
Just as a minor point, it's perfectly true that some crazy judges did take the view you've said about adverse possession, but you can all relax. Adverse possession has survived the trip to the Strasbourg court, and we still can have first-year courses with questions on it in England, just as you have them here. So there it is. But there were some people who did take that view.
Hi, Lee Liberman Otis with the Federalist Society. Probably foolishly, I'm going to try to take up Professor Ellickson's challenge here. I do wonder, and I, as a graduate of the law of the University of Chicago Law School and a big fan of Richard Epstein's, nonetheless, I do wonder if the hypothesis that it's at least equally good, if not better, to have strict liability in product liability hasn't been a significant and destructive rule adopted in law, and if law and economics didn't play a significant role, at least in legitimating it.
A nice example. I'm again trying to think about the history, Lee. What my view is that was, the Escola dissent, where Traynor pushes strict liability in products, is 1946, as I recall. So it's way before that idea kind of doesn't come out of law and economics. It comes comes much earlier than that. And the movement, I think, towards strict liability again precedes. Certainly any writing by Richard Posner and whatever. Guido Calabresi's work, I think, supported it, but that didn't appear till the basic book in 1970, and the revolution is largely over. So this is, again, an example where we academics like to think that we create the ideas and whatever, and then the common law judges might follow them. If you look at history, in fact, the sequence is often the opposite. Whether or not this is a destructive theory is the way I teach. Well, actually, I teach torts, believe it or not. Is that in many of its applications, the strict liability principle works identically with the negligence principle which preceded it, which is the identification of design defects, the failure to have warnings, and so forth. Is you do a learned hand cost benefit analysis, and there's not much change. So there is some change with manufacturing defects and whatever. My own I tend to agree with Brian is. It's a horrible thing to say to law students, but in my view, law matters a heck of a lot less than a lot of people think it does. I'm not sure that's Richard Epstein's view. So I think you're onto a nice area, and maybe there's a law review article there for someone, some specialist in the some skeptic who wants to take on law and economics could try to run with that one. Good try.
Johns, Duquesne University. I actually have a question about the EU versus Microsoft, the commission decision that just came down. It was decided in American courts, largely the same issues, and then recently the commission gave their final decision. And the economics, different professors have said this was a ridiculous decision, the commission shouldn't be able to say this, the European Union shouldn't be able to affect the market. But as you know, when the commission made their decision, Microsoft was compelled to do things that would affect in every other market. And this is a law and economics question because I'm just wondering how we can counteract that with our private system, how we can stop the European Union and other countries from making these decisions that have a broad sweeping effect no matter what we say.
I have not read the decision, and I only have sort of secondhand knowledge of it. I would. So let me just answer it in a somewhat general way. I mean, from what I've heard, it's troubling, but I would say one thing, that this panel was focusing primarily on the common law. I mean, Bob actually brought that in, and antitrust, I think, is a very interesting area. It's not my area. I did take antitrust, which maybe is unusual these days, but the problem with antitrust is that it certainly goes beyond the common law, although it's written in a very, American antitrust law is written in a very sort of vague way that invites a sort of common law style of decision making. And the oddity of American antitrust law is that the sort of economic approach to antitrust really, in some sense, is not the original intent, but it does seem to serve a lot of purpose. Now, the problem is that antitrust, as conceived that way, if we passed it again today, it probably would have more of that flavor. It does invite a lot of detailed economic decision making, but I think some of the dangers we've talked about or touched on here of law and economics being used in a highly detailed way do apply to some extent with antitrust. It's sort of unavoidable, but the idea of highly detailed judicial decision-making on the basis of antitrust as opposed to somewhat more rough and ready approach that doesn't require vast amounts of information, that tension has to be struck somewhat differently in antitrust in the direction of expertise, but it is really does raise some of the same questions. And part of your question has to do with the extraterritorial effects of some of these decisions, which are troubling as well. But the whole idea that antitrust not only requires a sort of heroic amounts of information, but also has in the past undermined its own goals, and I would say European Union competition law, if not a complete misnomer, does somewhat have the flavor, a different focus and flavor that seems not to be consistent with some of the spirit of American antitrust law. Not that that's been implemented in a wholly consistent way either. So antitrust, I would say, is a very troubling area, and what the allocation of decision-making should be and where judges fit into that and how different it is, if at all, from how different it is from the common law are really extremely tough questions, but I think some of the same trade-offs that we're talking about here apply there as well.
I'm going to let you ask your question, but first I want Gene to come up. Did you have some logistics announcements of great importance?
I had 2 or 3 logistics announcements. Right after this panel, the box lunches will be available right outside. I wanted to ask the people who run our student division to stand so you know who they are, so you can introduce yourself to them during the course of the symposium. So when you talk with them on the phone or by email, you have some idea who you're talking with. I'll ask them each to wave as I mention their name. Our student division director is Peter Redpath. Kate Beer just started with us. On his right, on the far right, is Elizabeth Leroy, who some of you have been in touch with. Elizabeth, raise your hand so they know who you are. High enough they can see it. And Daniel Sir, who's one of you. He's a third-year law student at Marquette right now, but he is going to be joining us as the deputy director of our faculty division starting in June. So while you're not dealing with him yet in that context, you will be if you're working on our chapters next year. So I wanted to encourage all 4 of you to students to meet any or all of our 4 students and introduce yourselves to them. And the last logistical announcement is for those who both have the spectacular type of academic record necessary and are interested in the Legal Academy, in room 236, we're going to have people will take their box lunches, those who are going there, and we'll have some discussion of some of the nature and challenges for those interested in entering the Legal Academy. As I say, that's a incredibly hard thing to do, but your absolute top schools and have absolute top grades, it's possible. After all, the panelists up here certainly did it. So anyway, thanks.
Okay, so in order to give people a chance to get their lunch and make it to that panel, we're going to make this the last question. So this is kind of a bit of pressure on you.
Well, my question is that from an outside observer, in the sense that I have no particular interest in private law, the underlying theory of law and economics seems fairly conspicuously a act utilitarian rule. And I'm wondering if the implementation of that as a rule, utilitarian rule, where he goes back, or whatever the judge is, and perhaps Posner, goes back and considers this maybe not as an economic rule, but as a rule of primary conduct, whether that might explain the half-hearted embrace of law and economics.
Yeah, I think in terms of resolving some of these tensions, thinking about things in rule utilitarian terms, with all the sort of deference to philosophers in terms of what problems remain with rule utilitarianism, can be useful. It is an interesting sociological fact that when people are trying to talk with each other in law and economic terms, it's very natural to fall into act utilitarianism. And for some limited purposes, that's fine, although when we bump up against the limits of law and economics, I think it's appropriate. One avenue that's appropriate is to think in more rule utilitarian terms and to see what maybe even non-consequentialist theories have to say and see if they can be reformulated into those terms. So as a sort of general strategy for making sure that law and economics doesn't get too off track, I think rule utilitarianism, with all of its own limits, is a way for law and economics to be somewhat self-correcting in a way that people can talk with each other. I think a lot of people use utilitarian rhetoric who are not true utilitarians. Some people are, some people aren't, but I think there are more people who talk in those terms than who are really truly utilitarians, even of the rule utilitarian sort. But I don't think that's terribly alarming. I think in a way, it's a form of communication, and if we keep that in mind, then some of the alarm about utilitarianism tends to go away. So maybe that's a sort of partial endorsement of the idea of rule utilitarianism as a solution to some of these dilemmas.
I just only have one comment. The trouble with applying economic views on the basis of acceptance of rule utilitarianism is, I think, the extreme difficulty in providing any sort of empirical basis for arguing that one rule rather than another rule, especially if you're fine-tuning the law, produces better economic effects than the other. It's hard enough to apply utilitarian theory of an act utilitarian sort to empirical evidence, but when you start applying it to rules, I mean, does the postal offer rule maximize wealth better than some alternative rule? I simply don't know how you could begin to get any empirical evidence on that whatsoever. So I think some of this is simply a way of talking about views adopted for really other reasons.
A great contribution that Henry Smith and Tom Merrill, who asked the question earlier, are making in their case book on property, which just came out, and is giving the traditional book by Jim Creer and others here at Michigan a run for the money, is that between ex ante and ex post analysis. So I'm no philosopher and whatever, but when you think about act utilitarianism, I think it's important to think about the time frame in which you're doing your analysis. And Henry made a nice point about the standard nuisance case like Boomer. Do you figure out what you should do after the factory exists that pollutes and whatever? If you look at it in that time frame, you might come up with a certain rule, but actually it might be more constructive to think back about when they made the decision where to locate their plant and whatever, and what rule makes sense then. And so I don't know how well that ambiguity has been worked out in philosophy, because I don't touch the stuff much.
I'm going to relent on the last question and let you have the last question.
Jason Texa, University of San Francisco. And I wanted to kind of bring this down a notch. I'm not an economic theorist. I really don't understand a lot of the legalese that's kind of come out of this discussion. It seemed kind of abstract to me. What I really want to do is kind of take you out of the role of being law professors for a moment and just kind of ask the question that he asked about 30 minutes ago, which is the life of a school teacher worth less than the life of an investment banker if you were sitting on the bench? All three of you.
I think at times societies make, symbolically correctly, do things to indicate the equality of people in their society. So we do this when we have one person, one vote rule. We do this on the right to education or whatever. An interesting example is the 9/11 fund, where there was a great debate about how to give out monies there. And I think the administrator of that fund thought in the end it might have been better to give out equal amounts and not take individual differences into account. That's not what they did. But I do think that there are some situations in life where that's symbolically appropriate. My sense is the tort system, in general, we don't do that very, very often. And in general, my first take on that is that you would create perverse incentives of various kinds, perhaps among other things, if you did that. So I would have other occasions in social life to make important legally symbolic statements about the equality of people, but that might not be one of them.
I find it a very difficult question to answer at all. Decisions of this sort are made every day of the week in the allocation of scarce organs in transplants, and where, you know, you've only got one liver or whatever it is, and you've got about 5 people, so how you decide between them. So I think the idea that we can escape deciding who's the most valuable it's just absurd. We just have to in many situations. And what I think we have great difficulty in having is any sort of overarching theory as to how we should make these decisions. I mean, some of those transplant decisions are not made on assessment of crudely value, but if one person drinks like a fish and the other doesn't, you're getting more sort of life out of putting the liver in one person and in another. And more life is generally regarded as better than less life, though I sometimes have doubts about that. But we do have areas in which we do take these decisions, and there's no doubt about that at all, and we're very uncomfortable with them.
Yeah, I agree with both Bob and Brian that it really partly it depends on which area we're talking about, and the problem with torts is that unlike in some of these other areas, unlike to some extent in organ allocation, it's very hard to disguise what we're doing, which we often do, and maybe it's important that we do disguise what we're doing in some contexts, because the very act of doing it openly is disrespectful of people's equal worth. As far as the tort system and lost wages, I agree with Bob that there are questions that of incentives and so forth that impact this, and as long as we can keep in mind that unequal damages for lost wages and so forth do not, we have to make sure to try to the extent we can not to send the message that this means that people are not of equal worth, then it's all right to do that. And I think you can tell that all 3 of us are uneasy, and precisely when we have to do these things above the board, there is a good question of whether we should even sacrifice efficiency if it really does get to be too symbolically a problem. And normally in the tort system, it seems to act in a way that this is not a flashpoint for symbolism, but with the 9/11 Commission, that's the 9/11 compensation system. That's not the normal tort system, and so we might have to re-ask the question. But that is, I think, the problem is that in some of these areas, like torts especially, there's no pillar to hide behind, and so that's why we're asking it. But we do make these decisions a lot of the time, and one would hope that part of the reason we don't do it openly is that we do have these concerns, and that the making of the decision is not meant to send that message. But when it does, then we and maybe some of these high-profile cases do involve that, then we have to do somewhat of a rethink, but probably not in the ordinary case.
All right. I would like to take the opportunity now to thank our panelists, and then we... And now you can have lunch.